Be ready. Start. In his testimony, Praveen Kumar Chabra, bracket PW2, brother of the deceased, had deposed that his sister used to complain that the appellant herein and the other co-accused used to harass her for bringing insufficient dowry, and on one occasion she had been sent back to her parental home on account of insufficient dowry. He had also deposed that about a month before the demise of Madhubala, in the month of May 1996, the accused had shifted their residence to premises number G17, Vikaspuri, and at that time all of them had made demands of new furniture and a color television from the deceased. PW2 had stated that 15 days prior to the demise of Madhubala, his parents had supplied a new double bed as demanded by the accused, but had failed to provide a mattress, due to which his sister was tortured by them. Dilip Kumar Chabra, bracket PW5, the other brother of Madhubala, had deposed that the appellant had demanded a catering van to enable him to settle down in his life. He stated that within a month of the marriage, the accused persons had started demanding a color television and other articles from the deceased, and once when Madhubala and the appellant had visited her parental house, their mother had paid a sum of 25,000 to the appellant in the presence of Shri Harish Chand Chabra, father of the deceased. He had deposed that the appellant's mother used to ask Madhubala's family members to arrange money for her son so as to settle him in life, as he wanted to start his own business, and 2 days prior to her death, their sister, bracket PW4, had received a telephonic call from the appellant that he had purchased a shop and had paid the earnest money but needed money to pay the balance amount of the sale price. In her testimony, Shrimati Anita Chaudhary, bracket PW4, Madhubala's sister, had stated that when the accused had shifted to their house at Vikaspuri, her father had given him a sum of 10,000 and provided a double bed on the demand of the appellant's mother. She had also deposed about the visit of Madhubala and the appellant to her parental home, and the fact that at that time a demand of 25,000 was raised and their mother had paid the said amount to the appellant. In case an officer in charge of a police station refuses to exercise the jurisdiction vested in him and to register a case on the information of a cognizable offence reported, and thereby violates the statutory duty cast upon him, the person aggrieved by such refusal can send the substance of the information in writing and by post to the superintendent of police concerned, who, if satisfied that the information forwarded to him discloses a cognizable offence, should either investigate the case himself or direct an investigation to be made by any police officer subordinate to him in the manner provided by subsection 3 of the section 154 of the code. It is therefore manifestly clear that if any information disclosing a cognizable offence is laid before an officer in charge of a police station satisfying the requirements of section 154(1) of the code, the said police officer has no other option except to enter the substance thereof in the prescribed form, that is to say, to register a case on the basis of such information. Section 156(3) provides that the magistrate may order such an investigation as mentioned above. These words clearly indicate and are relatable to an investigation which is to be conducted by the police under section 156(1) CRPC. The purview of the power of the magistrate concerned under section 156(3) CRPC does not travel beyond the said scope. It is limited in nature, and the magistrate under that subsection is empowered only to look to the application or complaint only to find out as to whether a cognizable offence is disclosed or not. Let me make it clear that registration of a FIR is quite different than the investigation of the same. It has been so held in the case of Bhajanlal Supra by the Apex Court. In para 41 of the said judgment, the Apex Court has held, we shall now examine as to what are the requirements to be satisfied by an officer in charge of a police station before he enters into the realm of investigation of a cognizable offence after the stage of registration of the offence under section 154(1). We have already found that the police have under section 154(1) of the code a statutory duty to register a cognizable offence, and thereafter under section 156(1) a statutory right to investigate any cognizable case without requiring sanction of a magistrate.